Now, on 105.9 FM and streaming worldwide on the WMAL app. O'Connor and Company.
Good Thursday morning to you. It's 7:06. It's O'Connor and Company with Larry and Mercedes. Coming up at 7:35, Troy Nehls, Congressman of Texas, on National Police Week. 8:05, K2 McFarland will give us her expert opinion of Trump's trip to the Middle East. And then 8:35, Lisa Terry of National Police Week. I'm Larry O'Connor with Mercedes Schlapp. As mentioned, good morning, Mercy.
Good morning. How are we doing, Larry? It's been a very
We're good.
morning.
I mean, I'm actually really excited about this conversation we're about to have and about the arguments that will occur later this morning in the Supreme Court. This is a historic day. Hans von Spakovsky is a senior legal fellow at Heritage Foundation. And Hans, this is about so-called birthright citizenship. And if you can just sort of give us an overview first, and then we'll get to actually how this argument might go down. This has to do with the interpretation of the 14th Amendment, which, of course, everybody knows was passed with regard to slavery and the post-Civil War era, where the disposition of enslaved Africans who had been brought here against their will and had been born here and lived here and raised here, what were we to do? And the solution was, well, they were to be offered citizenship. That has now been interpreted to anyone for any reason being born here in America, despite the circumstances of their parents entering our country, automatically gets U.S. citizenship. Have I summarized that properly?
You have summarized it properly, but the thing is that unless the justices somehow change their mind, the issue today actually isn't about the substantive merits of that argument. In other words, they're not going to be deciding whether Trump's interpretation of the 14th Amendment is correct or that of the challengers. What happened was that about all these blue states, about 24 of them, a bunch of alien immigration groups, they all sued and they went forum shopping. They only sued in blue states, Maryland, Massachusetts, and Washington. And in every one of those cases, these judges immediately issued what everybody is calling universal or nationwide injunctions to cover the entire universe, not just the people who actually were in the case, the parties in the case, but every single possible person across the country. So what the Trump administration did is they didn't file a petition for cert. In other words, they didn't file a petition asking the Supreme Court to review the entire substantive issue. Instead, they issued a request for an emergency stay of those lower court decisions. And they didn't even ask for the injunctions to be totally wiped out. What they asked was that the court tell these judges that their stays or their injunctions can only apply to the actual parties who sued in the case. So, for example, in one of these cases, several pregnant women sued. And what the Trump administration is asking is, look, the injunction should only apply to those pregnant women, not every pregnant woman in the country. And that's what the argument is. That's what the argument is about today. And by the way, this is very unusual. The reason being, the Supreme Court, their term ends in June. And normally they don't hold arguments past the month of April. And yet, what did they do? They scheduled these arguments for today. And usually, on these kind of emergency requests for a stay, they don't hold oral arguments. So the fact that they granted this, I think, is a comment on the criticism the court's been getting for not doing anything about not just the nationwide injunction in this case, but the numerous ones that have been issued on all these other cases that they've done nothing about.
Right. Hans, what do you expect? How do you think this is all going to shake out? I mean, we know that President Trump, he's hoping that a majority of these justices will also block courts in the future from pausing his policies on a nationwide basis. I mean, we're not only dealing with this on the Birthright citizenship case, but obviously with the Aliens Enemy Act that's being used to, basically deport illegal aliens and this issue of due process, and what does that define, or what does that look like? What can we expect? What's your prediction on how this is going to work?
I'm hopeful that the reason they, like I said, unusually scheduled oral arguments is because they're finally going to do something about these universal injunctions. And look, they just had another example of why allowing a single district court judge with limited jurisdiction to issue a nationwide injunction is a bad idea, because look, there have been several judges that have issued rulings, nationwide injunctions, saying, oh, Mr. President, you can't use the Alien Enemies Act. And yet on Tuesday, you had a different federal judge saying, yes, he can use it. So you have these two conflicting orders. And like I said, I'm hopeful that what the court will do is come down and say, government, you're right. Injunctions can only apply to the people who are actually named in the case. And I suspect part of this may have been prompted by the fact that, you may recall this, about a month ago, the court refused, led by Justice Roth, they refused to step into a case where a federal judge ordered USAID to pay out $2 billion in funding. And Alito wrote a stinging dissent saying that he was stunned that the majority would allow this to happen, that they would allow a single judge to order $2 billion in taxpayer funds to be paid out, money they probably would never get back, by a judge who was probably acting far beyond his jurisdiction. I think that may have prompted the Chief Justice to say, okay, we finally perhaps need to do something about this.
Hans, is there any chance that the justices will delve into the merits of this case in terms of birthright citizenship and sort of explore that aspect of this?
Yes. I mean, look, that's supposedly not what this oral argument is about today, but as you know, the justices can do anything they want. And I believe that, for example, that the liberal justices on the court, Brown, Jackson, Kagan, Sotomayor, I think they, in fact, will ask questions about the substantive issue of the 14th Amendment and the Citizenship Clause, because their whole attitude is going to be, oh, well, there's no merit whatsoever to what Trump is doing in his interpretation, and therefore, yeah, we should allow this nationwide injunction. That's how they will justify allowing these nationwide injunctions to continue.
Well, if that's the case, and I think you're right, I think that's one of the only arguments that they might have is that, well, we're right. It's just the righteous thing to do here. Then the merits of the case actually, then I think we should discuss so that people are sort of informed and armed. Do you mind staying with us a little bit longer so we can talk about that?
Sure. Yeah, no, happy
Excellent.
to do it.
All right, so we dive now into setting aside, the actual case in front of the justices today, which has to do with these nationwide injunctions and just one low-level federal judge being able to halt the agenda of the executive branch of government and their proper constitutional function. Specific to birthright citizenship, what does it mean, and is there any basis in the Constitution for it? We'll get to that.
WMAL, making sense of the news. Live from the Home Paramount Pest Control Studios. Home Paramount, the leader in pest control since 1939.
So we continue with Hans von Spakovsky, Senior Legal Fellow at Heritage Foundation. We're talking about now whether the justices might delve into the merits of the birthright citizen. They're going to hear these arguments eventually, I think, Hans, at some point. So let me, again, this was the 14th Amendment. It was set up to figure out the disposition of the enslaved Africans after the Civil War and what to do with them, and it was determined that they were to receive citizenship. Has it ever then been employed at the Supreme? Well, let me rephrase. Has the Supreme Court ever come down one way or the other on whether someone who is in this country illegally and outside of the confines of America's immigration laws, if they have a child, if that child should automatically get citizenship? Has they ever ruled on that?
They have never said that someone who is illegally in the U.S., that their children are citizens. There's been only three cases on this. They were all in the late 1800s. And I was just astounded, but it shows you how biased so many of these judges are. One of the judges out in the West, who immediately ruled against the Trump administration. He clearly had no time to do any research. Said, "Oh, it was blatantly unconstitutional what Trump was doing." No, wrong. Look, the first case on this was in 1872. That was shortly after the 14th Amendment was ratified. And what the court said in that case was that children, this is a quote, children of ministers, consuls, and citizens or subjects of foreign states born within the U.S. are not citizens. So they directly contradicted what all these judges today are saying. Just a couple of years later, there was another case in which an American Indians were not considered citizens of the U.S. An American Indian sued, saying, "Hey, I was born in the U.S. I should be considered a citizen." And the Supreme Court said, "No, you're not." And why is that? Well, because what the 14th Amendment actually says is anyone born in the U.S. and subject to its jurisdiction is a citizen.
Right. That's the key. Those are the key words.
That is the key. Right. Everybody ignores that second phrase. They say, "Oh, born in the U.S., therefore you're a citizen." Subject to the jurisdiction thereof, even folks who pay attention to that say, "Oh, well, if you're in the U.S., you're subject to our laws." That's not what that means. Yeah, a German tourist who's in the U.S., if he mugs somebody or robs a bank, yeah, of course you can prosecute him. But subject to jurisdiction back in the 1800s meant that you owed your political allegiance to the U.S. Well, a German tourist doesn't owe any political allegiance to the U.S. government. His political allegiance is owed to who? The German government.
Right.
And in fact, that German citizen, for example, if we go into a war and we bring back the draft, the German citizen can't be drafted. He can't be pulled in for jury duty, which happens to a citizen. So it's very clear that it does not apply to people born illegally. The third case, and this is the one everybody relies on, is a case from 1898 called Wong Kim Ark. And in that case, the Supreme Court did say that the Citizenship Clause would also apply not just to kids born of citizens, but to kids born of permanent resident aliens. But that was the extent of it. And if you look at the executive order that Donald Trump issued, he follows that case to the letter. He says people who were born to U.S. citizens or permanent resident aliens will be considered citizens, nobody else. So everybody out there who you hear saying, "Oh, this is a long-decided issue," they are wrong. We didn't take this attitude until apparently some point in the 1960s when some bureaucrat at the State Department, they changed the requirements for passports. Before that, they always wanted to know, well, who are your parents? Were they citizens? They just suddenly changed that. And ever since then, everybody has thought, oh, if you're born in the U.S., you must be a citizen. Wrong.
Yeah. Well, and they didn't contemplate like the mass illegal immigration, the birth tourism, and all the strain of these national resources. So, what we have seen are the judges themselves in these district courts and appellate courts, just pure judicial activism going on to try to stop Donald Trump on this particular case.
No, that's true. And look, you can tell forum shopping is going on because the District of Columbia, for example, is one of the cities that sued. Did they sue here in the District of Columbia? No, they sued in Massachusetts. So why would the District of Columbia go to Massachusetts to file a lawsuit? Because they're forum shopping, trying to get a liberal, activist, rogue judge who's going to rule their way.
It's outright. So let me just throw a scenario at you real fast, Hans, because, we live in a day and age where men and women both served in the military, not just here in America, but really globally. That's pretty much the norm now. So let's just have a scenario. Let's say a foreign country invaded the United States of America, right? You got to think in these terms. And let's say members of the military, the invading force from a foreign nation invading our country, there's a man and a woman serving in that foreign army, and while here invading us and actually engaged in a war with us, they actually give birth to a child. Are we to accept their child as an American citizen?
Well, according to all these judges, these liberal judges in blue states, yes. Yeah,
it's outrageous. It's ridiculous on the face of it, but that is exactly the scenario that they would accept if they interpret the Constitution in the upside-down, inside-out way that they are. And I'm not saying what happened with illegal immigration over the last several years with millions coming into this country is an armed invasion or an act of war, but it sure feels like an invasion sometimes. Hans, thank you, sir. Appreciate you joining us.
Sure, thanks for having me.
You bet. Hans von Spakovsky, Heritage Foundation. 7:23 now.